Tēnā koutou, tēnā koutou, tēnā koutou katoa. Hello, I'm Lee Godden, the Dean of the Faculty of Law here at Te Huringa Waka, Victoria University of Wellington. It's my great pleasure to welcome you all today, including our distinguished guests, to the Sir Kenneth Keith Lecture for 2023. If I could begin, please, with some very short health and safety information. For those of you not familiar with this facility, the bathrooms are around the corner on the left of the foyer. And because it is Wellington and it is New Zealand, in the unlikely case of an emergency, could you move to emergency procedures to drop, cover and hold? I'm sure as all international lawyers, you'll know what those are. I'm sure that's part of the general protocols you will be familiar with. And should we need to evacuate, please use the main doors and assemble outside the building perimeter. Now, as you can see, we have a change to the format for this evening. We are very grateful to Tim McCormack. Tim has COVID, and so you will see him actually on the screen rather than in person. But this is a magnificent effort on Tim's part to be still standing and talking to you. And I think it's a testament to the flexibility of our arrangements that we've also been able to assemble a wonderful panel this evening. Shortly, I will hand over to Professor Joanna Mossop to introduce our speaker for the lecture tonight. But before doing so, I would like to thank the Michael and Suzanne Boren Foundation once again for their support in this year's Sir Kenneth Keith Lecture. The foundation supports so many good things in legal education here in New Zealand. So please join me in welcoming Professor Joanna Mossop. Thank you.
Kia ora koutou, ko Joanna Mossop, toko ingoa. As Lee mentioned, I am a professor here at the faculty, and it's my distinct honour to be asked to introduce our lecture tonight. I first want to just say a few words about the Sir Kenneth Keith Lecture. This lecture was instigated in 2015 and it is held concurrently with the ANZIL conference, and I acknowledge the ANZIL delegates who are here today in the audience. So it's an honour of Sir Kenneth, and I'm sure that Sir Kenneth really needs very little introduction to most of you, so I'll just say a few words. But Sir Kenneth has a long and very illustrious career as an international lawyer. Many of us know him from his role as a judge on the International Court of Justice, but he's had many other roles in his life, and many of them overlapping and intersecting with international law. He's been a law clerk, an academic, a government advisor, a law reformer, and much more. So we are very thrilled and happy to be able to celebrate his extensive involvement in international law with the holding of the Sir Kenneth Keith Lecture tonight. It's very appropriate that we hold this lecture in conjunction with ANZIL. ANZIL brings together an enormous community of international law scholars and practitioners, and Sir Ken has been so supportive of many of us in the room, and it's really wonderful that we can take this opportunity to thank him for that. And as Lee mentioned, we're very grateful to the Michael and Suzanne Boren Foundation for helping us with this lecture tonight. Now, turning to Professor McCormack, and I'm very sorry, Tim, that we couldn't welcome you back to Wellington on this occasion. But Professor McCormack is a professor of international law at the University of Tasmania, as well as a special advisor on war crimes to the prosecutor of the International Criminal Court in The Hague, and he's had that role since 2010. He's provided law of armed conflict and international criminal law advice in a whole range of contexts, including to the alleged Australian Defence Force war crimes in Afghanistan, and has recently been engaged to provide law of armed conflict advice to Sir Charles Haddon-Cave's independent inquiry into alleged UK war crimes in Afghanistan. So Professor McCormack brings a wealth of experience, both as a practitioner and an academic, to share with us tonight. And I think it is very appropriate that he is giving this lecture. I understand that he's had a long and enduring friendship with Sir Ken and Lady Jocelyn. And so it's wonderful that you could be here to do that today. Before I hand over to Tim, I just really want to quickly acknowledge the members of our panel who will be speaking after Tim. Again, Sir Ken, I've already mentioned, and thank you again, Sir Ken, for filling in for at your own lecture. That's wonderful. We also have with him Douglas Guilfoyle, who's a Professor of International Law and Security at the University of New South Wales, Canberra, and an Australian Research Council Future Fellow. His research focuses on law of the sea and international criminal law, and he's recently written on command responsibility in relation to Australian war crimes in Afghanistan. We also have with us Andrea Ferger, who is a graduate researcher at Melbourne Law School. Her research focuses on international criminal law and state cooperation from an interdisciplinary angle. And her doctoral thesis examines the complexities of extraterritorial evidence collection in the context of investigations and prosecutions of core international crimes. But as well as being a doctoral student, she's had a decade as a practitioner in the field of international criminal justice. So again, she's a wonderful person, and I think you'll agree that they're three great panelists. And the discussion following Tim's words will be facilitated by Professor Alberto Costi, Professor of International Law here at Victoria University Te Herenga Waka. Just a note that after the lecture, we invite you to join us for refreshments, and the easiest way to do that is to leave by the top of the lecture theatre, and there'll be people there to guide you to those refreshments. So without further ado, Professor McCormack, can I invite you please to address us tonight?
Thanks very much, Joanna, and let me just say it's an enormous privilege to be invited to honour Sir Kenneth in this way, and of course devastating that the dreaded pox would seek me out just on the day that I was scheduled to leave Hobart to fly across to Wellington. So I'm really sorry I can't be there in person. But I've been reflecting on my friendship, as you indicated, Joanna, a deep and abiding one with Ken and with Jocelyn for over 3 decades, based primarily perhaps around shared interest in and commitment to increasing respect for and understanding of international humanitarian law that gave us the opportunity to be at various conferences and activities together, and so to grow in our personal friendship as a consequence of that. I've been reflecting on the opportunity to now be involved in helping to investigate allegations of serious war crimes by ADF and UK Special Forces in Afghanistan. And I take great heart and encouragement from my friendship with both Ken and Jocelyn as I undertake that work. I feel emboldened as a consequence of who they are and all that they represent in terms of their involvement in this subject area. Given my ongoing role as Special Advisor on War Crimes to the Prosecutor of the International Criminal Court, and also given that the ICC has jurisdiction over conduct on the physical territory of Afghanistan since 2003, I obviously needed Karim Khan's approval to be able to provide some support to Mark Weinberg and the Office of the Special Investigator, and more recently to Sir Charles Haddon-Cave and the independent inquiry relating to Afghanistan. I have Karim's approval on the basis that if he decides he needs to investigate the conduct of coalition forces in Afghanistan at any stage in the future, I'll have to recuse myself from any advice, and all the parties understand and accept that. Of course, I need to disclaim here, I'm presenting this lecture in my individual capacity. I certainly don't represent the Office of the Prosecutor of the ICC, the Office of the Special Investigator, or the independent inquiry relating to Afghanistan. I'm bound by confidentialities in respect of each of those responsibilities, and I'm sure this audience will understand that that imposes certain constraints. But I'm fascinated by the combination of New Zealand, Australian and UK initiatives to take seriously the investigation of alleged war crimes. And I'm very keen to talk about that tonight. I'd like to start with the national obligation to investigate alleged war crimes. I'm sure all of us would readily accept the proposition that states are obliged to investigate allegations of war crimes, but what is the precise source of that obligation, and how is the obligation satisfied? I naively in the past used to think a war crime happens, a person's tried and held accountable for it, but of course there's the extremely important matter of an investigation that has to go on between those two steps. The source and nature of the obligation comes from or is derived from a number of key treaty provisions. Common Article 1 to the 4 Geneva Conventions, we all know, requires states parties to respect and ensure respect for the obligations under the conventions. There might be some debate about how far ensuring respect in relation to the conduct of another state really extends, but there's no question that that obligation must surely involve a state itself respecting its Geneva Convention obligations and ensuring respect for them by its own armed forces. Each of the 4 Geneva Conventions list grave breaches of those conventions, and there's a common provision that is replicated across the 4 conventions to the effect that each contracting party shall be under the obligation to search for persons alleged to have committed or to have ordered to be committed such grave breaches, and shall bring such persons, regardless of their nationality, before its own courts. The ICRC has characterised this obligation as reflective of customary international law, not merely a matter of treaty law. And the ICRC customary IHL study says that states must investigate war crimes allegedly committed by their own forces or on their territory, and if appropriate, prosecute the suspects. It's also true that military commanders have an explicit legal obligation in relation to all of this. Article 86 and 87 of Additional Protocol 1 are critical here, because they're the provisions that first codified the obligation on military commanders. Article 86, paragraph 2 states that the fact that a breach of this convention was committed by a subordinate does not absolve his superiors from penal or disciplinary responsibility, as the case may be, if they knew or had information which should have enabled them to know that war crimes were being committed. And then in 87.3, we see a little bit more about what it is that commanders are required to do to initiate such steps as are necessary to prevent such violations, and where appropriate to initiate disciplinary or penal sanctions. Now, this requirement on the part of military commanders is taken very seriously in the ICRC commentary to AP1. The ICRC commentary talks about the importance of ensuring that there is no fatal gap between the treaty obligations themselves and their implementation in the context of military hostilities, and that military commanders are central to ensuring that subordinate forces comply with the law. I find that a fascinating obligation, and we see quite a bit of jurisprudence around what that actually means. From the ICC, for example, in the pre-trial chamber's decision in Bemba, the chamber notes the failure of a superior to fulfil his duties during and after the crimes can have a causal impact on the commission of further crimes. As punishment is an inherent part of the prevention of future crimes, a commander's past failure to punish crimes is likely to increase the risk that further crimes will be committed in the future. This same sentiment is reflected in a number of ICTY decisions from earlier in the course of the Yugoslav Tribunal's work. Let me turn to what it takes to satisfy this obligation, having identified the source of it. Like the lack of a definition of armed conflict, we know that none of the IHL treaties, the 4 conventions, or the 2 additional protocols actually define what an armed conflict is. Additional Protocol 2 comes close to a negative definition of what an armed conflict is not, but there is no definition of an armed conflict in those treaties. Neither is there any explicit detail about what is actually required to satisfy this obligation to investigate alleged war crimes. So we had some assistance in relation to that from Article 17, the provision of the Rome Statute that deals with the so-called principle of complementarity. The word itself doesn't appear in Article 17 or anywhere else in the Rome Statute for that matter, but has been coined to encapsulate the relationship between national courts and the International Criminal Court. National courts, that is the courts of the state of nationality of the alleged perpetrator, or the state, the territorial state, the state on whose physical territory the alleged crime occurred, both have a better claim to jurisdiction than does the ICC. The ICC, in fact, can only deal with a case where both states are unwilling or unable genuinely to deal with the investigation and or prosecution themselves. And in Article 17(2)(c), we read some examples of what unwillingness might mean. And one of those is the proceedings were not or are not being conducted independently or impartially, and they were or are being conducted in a manner which in the circumstances is inconsistent with an intent to bring the person concerned to justice. What does independent and impartially mean? Well, it turns out that there's a very great deal of jurisprudence from human rights law, particularly from the European Court of Human Rights, in relation to the alleged deprivation of the right not to be arbitrarily deprived of life, where states parties to the European Convention have allegedly failed to conduct an independent and impartial investigation. And I suspect that that if a future chamber of the International Criminal Court was required to assess the extent to which a national proceeding had been independent or impartial, they might turn to some of that jurisprudence to help flesh out the detail of it. Let's move from the obligation itself to the national reticence to investigate alleged war crimes. 20 years ago, I published a chapter in a volume of essays edited, I should say, by Mark Latimer and Philippe Sands. And the title of my chapter was Their Atrocities and Our Misdemeanors, the Reticence to Try a State's Own Nationals for International Crimes. That chapter was an argument for an international criminal justice system because without it, the record of exclusive reliance on national jurisdiction is desultory. Back in 2003, I found that most examples of domestic trials of own nationals fell into one of 3 categories. The first involved political regimes keen to distance themselves from the sins of an earlier regime. And we've seen this phenomenon play out in domestic criminal trials in Greece in response to the rule of the colonels, in Argentina following the so-called Dirty War, in Ethiopia following the fall of the Mengistu regime, and even in France with the trials of Maurice Papon and Klaus Barbie in the early 1990s, with public emphasis in relation to those trials on the evils of the Vichy regime's collaboration with Nazi occupation. The second category of trials involved the threat of, or the possibility of, or even the existence of international tribunals with jurisdiction over the particular state in question. So post-World War I, the Germans and the Ottomans or the Turks were able to conduct their own trials because the Allies, having threatened to set up Allied high tribunals, allowed them to do that rather than to experience the ignominy of international trials. and various Balkan states throughout the years of the ICTY, even though the initial approach might have been to trying the ethnic other, the Croatians engaged in trials of ethnic Serbs, the Serbs involved in trials of ethnic Croatians or Bosnian Muslims, began to shift to include trials of their own ethnicities. The third category involved national prosecutions of members of a state's own armed forces, and here the precedents are sparse indeed. I mentioned the US response to the My Lai massacre and the court-martial proceedings of Lieutenant Kelly and Captain Medina. And perhaps the one glowing example in the midst of a lack of them was the Canadian response to the atrocities perpetrated by the Airborne Regiment in Somalia, including the beating to death of a 19-year-old Somali boy who had breached the perimeter of the compound. If I were to update that third category in the 20 years since, I'd describe it as so far something a little bit like one step forward and two steps back. In relation to the US Uniform Code of Military Justice, there have been some examples where the system has worked exactly as it should. Sergeant Bales, for example, walked out of his compound in Afghanistan unauthorised in full combat gear with his assault rifle, went into the neighbouring village and executed 17 unarmed Afghani civilians. He was charged with and tried for and convicted of 17 counts of murder, as he should have been. But then Navy SEAL Eddie Gallagher, who was convicted of war crimes and described by colleagues as freaking evil and okay with killing anything that moved, was pardoned by President Trump because Trump considered him a hero. And there has been no, as far as I'm aware, no investigation of alleged CIA systematic torture in Afghanistan and in the so-called black sites that individuals were flown to. On the subject of political interference to try to pardon people, Prime Minister Netanyahu intervened in the military trial of Elor Azaria, the young medic, IDF medic, who shot point blank through the head a wounded Palestinian Abdul Fattah al-Sharif in the streets of Hebron, and was originally charged with murder, and subsequently that charge by the military prosecutor downgraded to manslaughter. But as soon as he was convicted, Netanyahu called for his unconditional pardon because he was a hero. And then I could also mention UK forces in Iraq, where more than 3,000 allegations of torture resulted in just one court-martial of 7 UK soldiers allegedly involved in the beating to death of Baha Musa in British custody. One of those accused pleaded guilty to inhumane treatment, but the other 6 were all cleared of charges because there is no evidence against them as a result of more or less obvious closing of ranks, were the words of the judges who presided over that court-martial. The ICC's report into the Office of the Prosecutor's decision to close the preliminary examination in Iraq and not apply for approval to open a formal criminal investigation was all about the fact that the OTP, despite being very unhappy about this conclusion to the investigation, was unable to determine that the UK was attempting to shield perpetrators from justice, which is the test, and so did not then try to move to a formal criminal investigation. Let me turn to the 3 initiatives that have been undertaken by New Zealand, Australia, and the UK. Given the paucity of precedent, these initiatives, I think, have been welcome. They've all proceeded differently because of our own national approaches to these things. And perhaps one common feature that I think is very important to identify and call out right now is the role of investigative journalism. It's a common feature across all 3 of the background that has that has acted as a catalyst for the establishment of investigative inquiries. In New Zealand, Nikki Hager and John Stevenson's Hit and Run. In Australia, Nick McKenzie and Chris Masters, as well as the ABC Four Corners program. And in the UK, the BBC Panorama program, as well as the Sunday Times. In relation to the inquiry into Operation Burnham, many of you will know better the allegations that gave rise to the establishment of the inquiry more than I do. But as I understand the key allegations, they related to a number of raids on villages, and the allegations suggested that there was faulty intelligence, that Taliban insurgents were present and weren't, that a number of civilians, including women and children, were killed in the raids, villages' houses were deliberately destroyed or damaged, and the New Zealand Defence Force did not investigate the allegations of civilian casualties and damage to civilian property, but rather tried to cover up what had happened. The Attorney General, in response to those serious allegations, established an inquiry into the Operation Burnham and related operations in April 2018 and appointed Sir Terence Arnold and Sir Geoffrey Palmer to conduct that inquiry. Sir Terence and Sir Geoffrey tabled the report of their inquiry in July 2020. The inquiry determined that the operations did occur, that some civilians were killed, and that there was some damage to civilian houses. But the inquiry also found the operations were not motivated by revenge, but that the intelligence that wanted Taliban personnel were present was accurate, and that the operation was undertaken consistently with rules of engagement and with international humanitarian law obligations. Ironically, in relation to the allegation of a cover-up of civilian casualties and damage to civilian property, the inquiry found that although New Zealand Defence forces were not aware that civilians had been killed at the time of the operation, they became aware of them within a few days when the ISAF incident assessment team reported that fact. Unfortunately, the NZDF misled ministers by claiming there were no civilian casualties, and over the course of several ensuing years kept repeating the claim, including that allegations of civilian casualties had been investigated and found to be baseless. The persistence with that fallacious assertion didn't help because New Zealand ministers repeated the claim several times on the basis of the advice they had received. Sir Terence and Sir Geoffrey acknowledged that their findings may well have disappointed Nikki Hager and John Stevenson. But from my perspective, the establishment of the inquiry was welcome and demonstrated a resolve to get to the bottom of the allegations. Presumably, if the findings were different, other consequences would have followed. There's no suggestion in the international legal obligation to investigate that an investigation has to lead to criminal prosecution, especially if the facts suggest that that is not warranted. In relation to the Brereton inquiry and then the establishment of the OSI, again, many of you will know the basic facts here. There were persistent rumours of summary executions by ADF, SAS, Special Forces over a number of years, and that had been confirmed to some extent by an informal and internal Australian Army review of SAS culture, which had been led by the psychologist Dr. Sarah Crumfitz. The ADF Inspector General appointed Major General Paul Brereton, an Australian Army Reserve officer and also New South Wales Court of Appeal judge, to undertake an inquiry into the allegations. Major Brereton had the powers of a royal commission in that he could compel testimony from witnesses without making any findings of criminal liability. To me, it's incredible that Major General Brereton managed to break the so-called code of silence, so prevalent, particularly in Special Forces units around the world, the code of silence that prevented more convictions in the particular incident of the death in UK custody of Baha Musa, for example. It's testament to some incredibly courageous men and women of the ADF that were prepared to testify as to what they had witnessed or been subjected to despite all their training and their acculturation to the effect that you do not rat on the brotherhood of the Special Forces. We now know that Major Brereton found credible evidence of 39 separate instances of murder of Afghani persons under control by ADF forces in 23 separate incidents involving 25 members of the Special Forces. That's a shocking finding, especially given Major General Brereton's finding that the SAS all understood the law of armed conflict and were well aware that executing a detainee unarmed and in custody was a war crime. Major General Brereton also found extensive credible information of the blooding of new recruits into the SAS, that is, being ordered to undertake their first kill as a bizarre rite of initiation into the regiment. He also found credible evidence of the use of throwdowns, the placement of an AK-47 or a radio communication device, or both, to demonstrate that the individual victim was a legitimate military target as one taking a direct part in hostilities. After the release of Major General Brereton's heavily redacted public version of his report, the Australian government established the new Office of the Special Investigator. I am grateful that Mark Weinberg has been appointed to lead that up. Mark Weinberg was a former Federal Court and Victorian Court of Appeal judge and also former Commonwealth Director of Public Prosecutions. He has a tremendous track record on independence and impartiality. And as we all know, first criminal charges have been laid on referral from the OSI to the Commonwealth Director of Public Prosecutions against Oliver Schultz. It's expected that other criminal charges will follow. One claim that Major General Brereton made, which I find staggering, is that his inquiry found no evidence that there was knowledge of or reckless indifference to the commission of war crimes on the part of commanders at troop, platoon, squadron, company or task group headquarters level, let alone at higher levels such as Commander Joint Task Force, Joint Operations Command or Australian Defence Headquarters. Nor is their inquiry of the view that there is any failure on any of those levels to take reasonable and practical steps that would have prevented or detected the commission of war crimes. I find that a staggering claim to have made. I understand that Major General Brereton lays primary and overwhelming liability at the feet of the patrol commanders, routinely lieutenants and sergeants, non-commissioned officers, who willfully hid the reality of what was happening from higher levels of tactical and operational command. But higher level commanders heard rumours of illegal conduct. And what did they do about that in response? Despite reports of Senator Jackie Lambie writing to the ICC prosecutor pursuant to Article 15 of the Rome Statute, asking him to investigate ADF commanders, she clearly doesn't understand the mandate of the OSI. Mark Weinberg has said publicly multiple times that he's not constrained by the findings of the Brereton report, and Chris Moratis has also reported publicly that the OSI is considering 50 or 55 incidents, significantly more than those identified by General Brereton. Just a few comments on the UK process. The allegations made in the BBC Panorama program and also made by two Afghani families who instituted judicial review proceedings in the UK as to why the deaths of their respective male heads had not been investigated. Those allegations are that UK Special Forces routinely executed Afghani males of fighting age in the course of operations to clear Afghani houses in search of wanted Taliban figures. Allegations of such extrajudicial killings were investigated by the Royal Military Police, but it's also alleged that those investigations were ineffectual and no charges have been laid as a consequence of them. In December last year, the UK Secretary of Defence announced the establishment of an independent inquiry relating to Afghanistan to be led by the respected senior criminal law judge, Lord Justice Sir Charles Haddon-Cave. He's now assembled his team, visited both in New Zealand and Australia to learn whatever he can from the Burnham inquiry, the Brereton inquiry, and the work of the OSI, and is now embarking on a fact-finding inquiry similar to that conducted by Sir Terence and Sir Geoffrey. His terms of reference require him to report on whether there is credible information to suggest that war crimes have been committed. If he does reach such findings, I have no doubt he will recommend formal criminal investigations. It's apparent to me that the UK takes very seriously the example set them by the New Zealand and Australian initiatives. Perhaps it's the case that when you take yourself as a society seriously for the export of the common law, it's also important that you take seriously a good example set by the former colonies that now show you how to go about the investigation of war crimes by their own armed forces, and seriously. Why does all of this matter? One key feature of the West's reaction to the Russian invasion of Ukraine has been a rush to support the investigation of war crimes, crimes against humanity, and genocide, and high-level discussions of a serious proposal to establish an ad hoc tribunal for the crime of aggression. Western nations have almost been falling over themselves to be seen to help. That willingness to commit resources is most evident at the ICC, with the deployment of secondee experts, military analysts, information analysts, investigators, trial lawyers to support the OTP's Ukraine team. That support is welcome and beneficial in the substantial increase in capacity to deal with massive data and an exceedingly complex military campaign in real time. Imagine, though, if that commitment to Ukraine was accompanied by an indifference on the part of New Zealand, Australia, and the UK in the face of allegations of war crimes perpetrated by our own special forces in a country over which the ICC has jurisdiction. That would be completely hypocritical. And I, for one, am grateful that my own government is taking these allegations seriously. In all three situations, it is clear that the spectre of the ICC, with its jurisdiction over alleged Rome Statute offences on the physical territory of Afghanistan, is an incentive on states to take seriously their national obligation to investigate allegations of war crimes by its own armed forces. Sir Terence and Sir Geoffrey said as much explicitly in their report. Mark Weinberg has also articulated this same sentiment publicly. From an ICC perspective, these developments in New Zealand, Australia, and now in the UK are welcome precedents for other states parties and non-states parties alike. The ICC wants to support any state that is committed to accountability for alleged international crimes. It can't possibly prosecute all the Rome Statute offences that occur, even where it possesses jurisdiction. These three national initiatives are precisely what the ICC prosecutor has in mind when he speaks of positive complementarity, and I'm grateful to see them being played out. Thanks very much. Looking forward to hearing from the panel.
Thank you very much, Tim, for an enlightening presentation and for giving us so many important elements to discuss now. So what we will do first is that we will get the panel members to talk to about 5 minutes each. We will have Andrea, who will speak about cooperation between states and the International Criminal Court. Then we will have Douglas, who will discuss some issues about the Brereton report. But beforehand, I will ask Sir Ken to start the proceedings of the panel. And because it's a Sir Ken Keith lecture, I told him he can speak about whatever he likes for 5 minutes only. Thank you very much.
Thank you, and thanks very much, Tim, for your great presentation. Tomorrow it's going to be a session on the outcome of the armor. Get a laugh for that. I think about great coffee. The armor court. The Inspector General of Defence which I was especially pleasant. And I enjoyed 35, of the pension policy. And just in respect to that, unfortunately, in terms of the guidance that was the operation Nana, where prospect was handed over to a place where it was very likely that he would be tortured, and he wasn't. That's really not. And we'll be talking about that. I thought I would go back to discussion. You and I had some while ago when we were putting together a book on Asia Pacific. And the person who had casualties. 1975 and 76. Interest. He picked up the short straw and the work there of David enforcement, which could be pretty gloomy. It's that issue of David enforcement. There were questions about the rules relating to updating behavior. Pension from 1899 to 7 others. And third, more relating to it's also issue stated by Hans West relating to conventional weapons and which is there. That is, of course, there onto convention, unconventional weapons. I didn't sit in the car with that gentleman, so I had taken the initiative. And changed. But that's very important to the whole of that. Now, on enforcement, the system in Pakistan and we made some real progress. But then 1977, that text governed and for quite how that happened. We did not support this, but then turned out that it was a big deal. Still, as yet, notwithstanding that it's every couple of years. The second matter that I mentioned about rules relating to rules relating to water was very substantial. Initiative arose from power and confidence. Celebration. And in that case, people are saying about the rights of people and more things. And so that was real elaboration of the basic all of that position here, declarations. Now, it's interesting in terms of dyads. But that text was very severely judged by the combination of the ICC. But it's really interesting. The customary law stuff is really resurrected. And that also various including one of the things system to family having required what's the movement and to the taken in the legacy and please the number of the basic principles available were adopted. Well, say what I did enjoy notice a very strong comment about the remarkable finding Brereton in relation to the lack of responsibility for change. Thank you. Thanks.
That gone on. Years, and now I'm also working this field. So I will, for tonight, I just have a few reflections on how the cooperation and relationship between the ICC, the prosecutor in particular, and states has changed over the last 10 and 12 years. And so when I started the report in 2010, and this relationship was quite one-sided. So the opposite, of course, of the court was sort of the last resort, and there was a bit of an expectation that the state would kind of feed evidence and material into the court. What has changed is, I find that quite interesting, that today states are really taking on more of this duty that people speak about you to investigate because they do international crime or either not or on their character. We see this more and more in Afghanistan, in Australia, and in addition to this, we also have other states. Third states. They're opening investigation. We did a lot now in relation to in addition to Ukraine, opening the investigations. And so what we've seen is necessary also quite a big change towards positive approach between narrative concept of the. And so what this really meant is that government was encourage domestic investigations in the acknowledgement that the court didn't do it all, and that it was only going to be just a small portion of cases, and the ICC the big load of work that can be done by domestic jurisdictions. And what came with this knowledge was overall an increase in of the sharing of evidence with domestic jurisdictions. So the ICC, per Article 92.
Okay, is this better? Should I just continue?
Yes.
Sorry if you missed the beginning of my presentation. So what I wanted to highlight is, so with this new approach, a positive approach to complementarity, the ICC of the Office of the Prosecutor has also started sharing evidence much more with domestic jurisdictions. So it's now much more of a two-way street. Domestic jurisdictions provide evidence to the court and vice versa. What has also been happening in the last maybe 3 to 4 years is the emergence of a new cooperation mechanism, which is called joint investigation teams. That's something I'm currently researching on, so I just wanted to flag it here for people who are interested. This is kind of a new practical mechanism of cooperation in which states and potentially organizations such as the ICC jointly investigate certain criminality. So these mechanisms come out of transnational criminal law and are particularly active in certain regions, such as, for example, in Europe. But over the last 3 to 4 years, they kind of have made appearance in international criminal law. It is my belief that the reason they appeared is because they respond to two features of the current international criminal law landscape, which is that we have more and more actors that are trying to investigate and prosecute international crimes, as we've seen, for example, in Ukraine. And also it really highlights the difficulty of accessing and sharing of evidence. So joint teams, in a sense, are kind of hoping to respond to these challenges. There are a few core crimes joint teams around. One that's the most, I guess at the moment, the most famous one is the one in relation to Ukraine, which currently consists of 7 European states, mostly Eastern European states, including Ukraine as a territorial state. And it also includes the Office of the Prosecutor of the ICC. So that's a quite unique, it's the first time the ICC Office of the Prosecutor joined such a joint team. So I have a bit of a critical view of these joint teams. I don't think they're as good as they kind of sound like, but nevertheless, I do believe that their emergence and also this new approach to complementarity of the ICC Office of the Prosecutor reflect a recognition of the limits of the ICC, a recognition of the limits of international criminal justice, and a growing recognition that most likely the future of international criminal justice is domestic. It is domestic investigations and prosecutions. In the end, I do believe that's a good thing, and I think it's the way forward if we want to increase accountability for core international crimes. Thank you very much.
Thank you. My name's Douglas Guilfoyle, and it's an honour to comment on Tim's paper. I just wanted to go back to the Brereton report's rather extraordinary findings about the lack of any ostensible command responsibility and offer some very short reflections on the politics of command responsibility in Australia at the moment and the symbolic capital that the International Criminal Court holds in Australian politics, and how different constituencies have sought to use or mobilise that. So I think Tim in his paper was right to say that the two drivers for the establishment of the Office of the Special Investigator in Australia were investigative journalism and the spectre of ICC intervention. Certainly for a Conservative government that lost no opportunity to wrap itself in khaki and the flag whenever it could, the idea that any of our diggers would be sent to The Hague was anathema. But the flip side of that was, for a certain element of the base and the party room, which didn't want necessarily to see any members of the Australian forces tried under any circumstances, it provided political cover for the establishment of the OSI, to be able to say, if we don't do this, there is a risk that the ICC will, even though I think objectively that political risk was relatively remote. But there's also been another division that the Brereton report opened up, which was between an increasingly angry and vocal subset of the veterans community that feels that frontline troops are being hung out to dry in these processes, and that those with questions to answer, both at higher levels of command and the political classes, are not seeing any of the heat. And the voice for a lot of that dissatisfaction has become Senator Jackie Lambie, who falls within that class of Australian politicians normally referred to as a colourful character. But nonetheless, she is very sincere on veterans' issues and has tapped a real vein of discontent. Now, though she has made this sort of highly media-charged Article 15 referral to the ICC, and while, as Tim says, it's not apparent from a lot of her public comments that she understands the role of the Office of the Special Investigator, which as a veteran herself who spent time in the military police is odd. Nonetheless, her press releases do make one point that I found at least partially compelling, which is to accuse the Australian legal system essentially of a degree of hypocrisy around command responsibility, in that the standard we have said that should be applied internationally to the rest of the world in signing the Rome Statute is a higher one than we were prepared to implement in domestic law. And the way that argument runs is as follows. Under Article 28A1 of the Rome Statute, a military commander is responsible for the war crimes of subordinates if they either knew those crimes were being committed or, owing to the circumstances at the time, should have known. Now, while that's not a strict liability standard, it is at least an obligation of due diligence. However, what appears in Article 268(115) of the Australian Commonwealth Criminal Code as the words that a commander either knew or, owing to the circumstances at the time, was reckless as to whether crimes were being committed or had been committed. And recklessness in Australian law requires an actual awareness of substantial risk. So it's a technical point, it's a somewhat higher standard. The two standards are different, and the international standard would appear to be easier to satisfy. But I don't think the substance of this, again, is actually realistically a path to ICC involvement. It's about making part of the public conversation how far should command responsibility cases extend. And ultimately, that's in the hands of the OSI, and we have to see how that plays out. But one way or the other, I think we're up for years of very difficult discussion around these trials as they unfold in Australia. And I'll leave it there.
Thank you very much. I think we have time for 10 minutes. So we're at time to 10 minutes for questions. Maybe we'll take 2 or 3 at a time. And if you could please keep your questions short and to the point so that it leaves more time for our panelists and Tim to provide answers.
G'day, Tim. Sorry to hear you're sick. Really great presentation. I want to ask you a question about the breaking of the code of silence that you spoke about. And you were able, or Major General Brereton was able to do that in Australia. And it would seem that the Royal Military Police were not able to do that in the UK. And I wonder if you can draw any conclusions for us about the who of investigations into war crimes based on that.
Thanks very much, Kevin. And I really appreciate the shift to the different microphone, because I found it very difficult to hear Sir Kenneth in the first part of Andrew's presentations. After that, it's been a breeze, and I can even tell from your voice who you are, Brigadier Reardon. Nice to have a question from you, and I'm really sorry I can't see you in person. I think
it's Chris Griggs.
Oh, there you go, Chris. I saw Kevin on the screen before, but I'm really sorry, Chris and Kevin, for making an assumption. It's great that you're both there, and I really appreciate the question. The who of the investigation's obviously critically important, and I think that one thing Sir Charles Haddon-Cave will need in his inquiry to be able to get to the bottom of the allegations against UK Special Forces are some insiders who are prepared to testify before his committee of their own experiences, what they were subjected to or what they observed and witnessed. Because how else can you break that code of silence? And one of the things I find fascinating about those who have been prepared to do that in relation to the Brereton inquiry is that they are so traumatized by what they were subjected to. They know so clearly that it's wrong. They've been prepared to place a higher emphasis on the importance of the truth and their own ability to explain what happened than the commitment to the brotherhood, if I can put it that way. So that's, I mean, that's incredible, I think. And for me, it's the answer to the almost unlimited number of times people have said to me, how can you, as an academic, pass judgment on these people sent off to war? You've never been in military operations. No, that's correct, I haven't. But the people who are coming forward to explain what's happened are the people who were deployed as well. So, yeah, I mean, I don't know if there's a magic formula to how you flush those people out to get them to be prepared to testify, but they are clearly essential to getting to the bottom of the allegations.
And for another question, we have one there, and then after that, done.
I remember years ago about these cases, and about New Zealand cases, I'm actually quite disappointed about the inquiry, the results, the conclusion they draw, because it's pretty obvious. They are from the people who leak. Those people served there. They were there. They witnessed what happened, and it is a revenge motivated crime. And how could you say you don't know?
Can you please stick to the question?
Yeah, but anyway, what I'm saying is that about I think they all know the rule of the engagement, and they broke it. And when things happen, they usually got pressure or even threatened by those people in power or trying to cover it up. But anyway, in the end, maybe some results came out to say this is not right. But if the result is not good enough, is their next step up still goes to International Criminal Court, or just a domestic one is just good enough?
Okay. Did you understand the question?
Yeah, I think I do. I think the answer is that the court, the International Criminal Court, must be satisfied that the national proceeding was a representation of a lack of willingness to take seriously the allegations. That's a very difficult and challenging decision and judgment to make, because the International Criminal Court's putting itself in the position of saying that what happened at the national level was about shielding the individuals who allegedly perpetrated these offences from justice. And we know from the experience with UK forces in Iraq that the Office of the Prosecutor is very reluctant to make that decision, because then they have to test it in court and show that from their perspective, they have to prove that in that case, the UK shielded the individual perpetrators from accountability and justice, even though a national proceeding has gone on. I think that that's unlikely to happen, unless the court is convinced, or the Office of the Prosecutor is convinced, that what's happened at the national level is in fact a sham and only been set up to make it look like we're going through the motions, rather than taking the whole thing seriously in a bona fide way.
Thank you very much, Tim. A very last question, Don Rothwell.
Don Rothwell from the Australian National University. Tim, I'm sorry to see that you're not here, but thank you for that wonderful presentation, and also thank you for your forthright comments. And Douglas, can I also thank you for your observations about the events of last week. In media that I did in Australia last week, I described Senator Lambie's Article 15 referral as audacious. Tim, I'd just be grateful for your reflections on whether or not this action by a member of the Australian Senate could be seen as a possible politicisation of Australia's relationship with the court.
Thanks very much, Don. And I'm also sorry I'm not there. It's devastating to be stuck here in my study at home in Hobart. But yeah, thanks very much for expressing those sentiments. I appreciate it. Look, I think the reality is that the court and the prosecutor, I should say, the prosecutor receives Article 15 approaches all the time. And sometimes they come from politicians, sometimes they come from NGOs, sometimes they come from concerned individuals, come from all sorts of different sources. And I don't think that Senator Lambie's approach will be interpreted as an attempt to politicise the relationship. I think it'll be, seen in the for what it is. And I mean, one thing that I can say, I'm sure, is that the OSI and the ICC has a very positive working relationship. I mean, not unlike what Andrea described, although it's not a joint investigation, but there are open lines of communication between the OSI and the OTP, and I don't think there's anything secret about that. And the ICC understands the work that the OSI and the work they're trying to do, the approach they're trying to take, and that they aren't limited by General Brereton's recommendations and are looking beyond those recommendations to other incidents and to other individuals. So I don't think that they'll be taking Senator Lambie's approach seriously. I'm sure someone will write a polite letter to her and thank her for her concerns, but assure her that while there's a national process going on, the Office of the Prosecutor will allow that to run its course and then make its evaluations afterwards about whether the job was adequate or whether there were gaps in it that the ICC needs to consider. And just on the subject of Senator Lambie as a colourful character, I'd like to say that she represents the good people of my hometown, Burnham, and the northwest coast of Tasmania. And I think she does a magnificent job of representing the people of the northwest coast. So I don't mean to suggest that in suggesting that she doesn't seem to understand the role of the OSI, I'm not criticising her for everything that she says or does.
Thank you very much. Thank you very much, Tim. I see that I think time is up, and I don't want to stand between you and some refreshments. But I just, in conclusion, and for the vote of thanks, I just really want to thank you, Tim. No one is more fitting than you, Tim, to fill the shoes of a Sir Ken Keith lecturer. You're not only an academic, but also one with great practical experience around the world. And Tim, you have an influential voice, but what I appreciate very much is how you can say things in a very simple way. You carry a good message. And for me, tonight, you embodied, I think, the theme of this conference, resilience, by joining us despite being so unwell. So really, thank you very much. But on a more serious note, really what you got us to think about is the importance of the greater willingness of states to address civilian harm in military operations. Also, the importance of cooperation between international organizations like the International Criminal Court and states, and also the importance of having recorded accounts of atrocities, and that hopefully can lead to more and more prosecutions, but also hopefully in the future, non-repetition of these, what we see in the headlines, and change in practices. So really, thank you very much, Tim, for your presentation. And if I may just add before I invite you to go up to the mezzanine is to take 1 minute to just, again, show how appreciated Sir Ken you are. And this lecture, what I see in the audience are former students, current students. I see former and current government advisors. I see members of the judiciary and former members of the judiciary. And I think this shows how esteemed you are in this country, but also as a very good friend of ANZL, that you've been always a great supporter of ANZL throughout the years. And it's just fitting that we end this first day of the conference with the Sir Ken Kidd lecture when it is in Wellington. So I would really like you to join me in thanking Tim for his excellent lecture, the members of the panel for their remarks, and thank you very much for this Sir Ken Kidd lecture to the Brereton Foundation. And so thank you very much. Have a good evening.